Hi, Michael Kushner here. It's time for another HOA Q&A where I respond to questions posed by California homeowners who live in HOA-governed communities. This question came to us from the same YouTube listener who posed the question that I handled in the prior HOA Q&A. And he asked, is it legal for our general manager to recommend that a homeowner's microphone be shut off during open forum because the issue being addressed by the member was not on the agenda for the meeting? That doesn't seem right. You are 100% correct, and your HOA and the general manager are dead wrong. This is not right. More importantly, based on what you described in this and in your prior question, you have a serious problem with your HOA, as it seems that not only is your board utterly ignorant of its legal obligations, but so is your purported general manager. Under Civil Code Section 4925A, members have the right to speak at board meetings. This time is often called open session or open forum. And under Civil Code 4930, a member's right to speak during open forum includes the ability to address any matter within the jurisdiction of the HOA, not just items that appear on the agenda. To be clear, the agenda item applies to topics being discussed by your board, not members during open forum. Also, under Civil Code Section 4925B, the board can adapt reasonable time limits for comments, such as typical 3-minute rule. But the board cannot cut someone off early or shut off a member's microphone simply because they don't like the topic. It would be one thing if the member was using profanity or making threats or discussing clearly inappropriate topics. But that does not appear to be the case here. As for the general manager being the one who made the request, for your purposes, that's irrelevant. Whether the general manager doesn't understand the law or is choosing to ignore it, under California law, the general manager's actions are going to be imputed to your board because he was acting within the course and scope of his duties as the general manager. That means that the general manager's actions are legally the same as if the board took those actions. As I said, you have a serious problem with your board, and the sooner someone educates them, the better. I'm Michael Kushner, and this has been another HOA Q&A. If you enjoyed this segment, please hit the like button and subscribe to the podcast HOA Hell. If you have any questions for me that you'd like featured in a future HOA Q&A segment, leave a comment. Until next time, have a wonderful day.